Fantastic. Hello, my name is Sadie Caron, and I am the Communications and Fundraising Manager with Hub Cycling. And I am so thrilled that we get to host two amazing lawyers from one of our organization members and longtime supporters and sponsors, Richards Beal Sutton. Our office, Hub Cycling, is located on the unceded territories of the Musqueam, Squamish, and Tsleil-Waututh nations. Since time immemorial, they've been the stewards of our land and waters. And today I'm so excited to learn all sorts of things about the estate planning cycle. And this is such a fantastic pun that we have here from Max. So I'm going to go and pass it over to David.
Thank you very much, Sadie, and welcome everyone. Just by way of background, many of you may know me. I'm a partner at Richards Beal Sutton. I've been a bike lawyer for most of my 36-year career, and I've promoted safety and the pursuit of accountability for negligent motorists and legislative change to improve the rights of cyclists. Our firm, I'm happy to say, was present at the birth of the predecessor to Hub, which was the Vancouver Area Cycling Coalition way back in the 90s. And we've been proud to represent Hub members for a very long time in various facets of their lives. My goal is to ensure this great synergy between RBS and Hub continues, and our respective organizations continue to benefit from this relationship. Now, Max Scioletto is a lawyer at our office, and he's a big part of my succession plan. He's here to speak to you today about a closely related theme, and that is estate planning. So he's a trusted member of our estate planning group, and just as my generation is passing the baton to his generation of lawyers, so you must take that step and prepare for the day when you shuffle off this mortal coil and entrust your affairs to someone else. Preparing a will is an essential step towards ensuring your legacy is not tainted by disorder, disarray, and dispute or uncertainty. A will is a chance to get your affairs in order and ensure you're not leaving your loved ones a mess to clean up after you're gone. That's not the memory you want to create for your successors. So on that note, I commend you to Max Scioletto. He's my personal estate planning lawyer and a remarkably good individual. Max.
Thanks, David. That was very kind of you. Just so everyone knows, I asked David to come up with about 5 minutes of compliments for me, and we're at the 12:04 mark. So we're a little shy, but I'll try to make up the difference with some estate planning information. So if you're a Vancouver area cyclist, you're probably already really familiar with David Hay's name. He's a longtime cycling advocate, and he's been recognized many times over as Vancouver's best bike lawyer. And as David mentioned, he's fostered this incredible relationship with Hub, and I'm incredibly grateful for it because I've been able to sort of ride David's coattails, or I promise this is my last cycling pun of the presentation, but to ride in his slipstream through this relationship with Hub, and I've been able to get involved working with Laura, Jane, and Nav on the Motor Vehicle Act Reform Group. And I was also able to present an award at the Hub Bike Awards this year. So I'm the biggest fan of Hub. So we're really lucky to kind of continue to grow this partnership. So I don't know if you were all sort of looking forward to hearing Vancouver's best bike lawyer talk for the next 45 minutes. You're sort of out of luck. You get me. I don't know if have you ever gone to one of those movies where they sort of promote it as this movie starring a big A-list actor and he gets killed off in the first 15 minutes? This is sort of like that. I didn't I didn't want to kill David off out of malice, but if you look at him, David's just an intimidatingly cool person. He plays in a band, and his energy is he's always just so laid back and cool. So I get very intimidated having to share a screen with him. So I put an end to that quite quickly. And if you attended our estate planning presentation last year, I'm really sorry I didn't come up with a new title for it, but I just love this one. One housekeeping note, I was telling everybody, I've sort of thrown caution to the wind. My dog is sleeping under my desk, so if you hear any grumbles, it's not my stomach or anything. It's Mookie making his presence known. But he's sleeping right now, so I'll try to speak somewhat quietly. So our law firm, Richards Beale Sutton, is the oldest firm in British Columbia. And I was here since day one. We have two offices, one located in Surrey and the other one in downtown Vancouver. And one of the things that I always think really sets our firm apart is the size and strength of our wealth preservation team. That includes litigation, estate planning, family law. We have this group that's really structured to protect family wealth. So I'm lucky to be able to work down the hall from some of BC's best estate planning lawyers and most experienced and creative people. But thankfully for you, I'm a lot cheaper than them. So my slides from last year said we had 50 plus lawyers at the firm and 18 in my group. I went to double check that on the website. And we've got the same 18 people in our group, but it turns out we got to 60 lawyers. So I had to update the number. I was going to keep the plus sign, but I figured it might be a little deceptive. So we got 60 lawyers on the dot. So ultimately, it's my job to talk to people about what happens when they die. It's nothing to do with ghosts or religion. My role is simply to help people set up a structure that ensures their loved ones are taken care of, and your stuff ends up in the hands of the right people or organizations. So it's Make a Will Week again, which is sort of the occasion for this annual presentation we do. It's actually next week. It starts on the 6th, but we wanted to get in early on it. And I mean, there's a part of Make a Will Week that it sort of feels like Valentine's Day for greeting card companies, how it's just sort of designed for law firms to get people to make wills, but it's a good trigger for people to start thinking about this. Because I know personally that estate planning is something that's really easy to procrastinate on. I will sometimes have clients who are slow to respond to my emails and slow to get things moving. But my wife and I just went through the getting our life insurance set up. And I found that my tendency was I was just really slow to get back to people. So I understand that it's super easy to procrastinate on, but it's important to get in place, because once you've got it in place, then it's one less thing for you to worry about. It's interesting because a lot of the people that I meet with, they're either really proactive people, or they're going on a big trip, or they just had kids, or they had a recent death in the family, or maybe they had to deal with someone else's estate, and they know how big of a headache it is to deal with an estate that's not set up properly. Otherwise, if you are in good health and there's no major issues coming up, making a will is something that you can do between now and the date that you lose capacity or the date that you die. So you have this really, really great opportunity to deal with it right now, rather than pushing it off until you've run out of time. So I have about 40-ish minutes to teach you everything you're ever going to need to know about estate planning. I tried to pack in as much information into this presentation as I could, but I'm going to speed through a couple sort of complicated subjects. So if you have any questions, as Sadie mentioned, we're going to have questions at the end, or I'll leave my contact details up at the end, and I'm happy to take any phone calls or answer any emails. One of my favorite parts of the job isn't necessarily all of the billable hours that I get. It's sometimes when I get a call from someone who is dealing with an estate or has a random question, and I get to kind of nerd out because I tell everyone I'm the biggest estate planning nerd out there. I love talking about it. So feel free to reach out to me anytime. So this slide here, I want you to sort of look at it and think of your life on a spectrum. You have today, like I said, today until the date that you lose capacity or the date that you die to set up your estate plan. So you can set it up today and then decide maybe the people I've appointed or maybe the people that I'm making distributions to aren't the right people anymore. So you can update it later, but you've got this window of time right now to deal with all of this. Assuming you're 19, there's it's your blank canvas. You can do anything you want with your will. Otherwise, if you don't have a will in place, Premier EB or whichever Premier gets voted in is going to be able to decide what happens to your estate for you. So today I'm going to talk about a couple things. I'm going to talk about incapacity planning. We're going to talk about estate planning, and I'm going to talk about a couple alternatives to estate planning and some additional considerations that you should be aware of. Now, incapacity planning is something that I'm really passionate about because it gives me an excuse to talk about my grandma. My grandma and I were incredibly close. She was basically like a third parent to me. And we had this really special bond, and she made it all the way to 99. And towards the end of her life, she started suffering from Alzheimer's disease. And I remember when I was in university, I wouldn't take vacations to any tropical places. I'd always go back to my hometown in Campbell River to visit my grandma and soak up as much time as I possibly could with her. And she would tell me all these details about her and her husband going to Hawaii and the time they ran into Bob Hope and all the golfing trips that they went on. But then the nurse would come in the room and ask, where are you? Or what day is it? And she would have no idea. We actually developed this strategy where anytime I saw the nurse coming down the hall, I would sit on the side of her bed and whisper, "We're in Campbell River. It's Monday, November 6th. And then she would just relay that to the nurse. But unfortunately, my grandma came from a generation where anytime a difficult or uncomfortable conversation came up, she would always just change the subject. So she never had the conversation with her kids about what she wanted to have happen if she's towards the end of her life and they need to make a decision about life support. And she never got incapacity planning documents in place. So when that time actually came for her to move into a care facility and for them to make a decision about when to pull life support, there was a disagreement with my mom and her 4 siblings, and no one knew who was in charge and no one knew what grandma wanted. And it created a bit of tension with the family that's still kind of present at times. So since I've become a lawyer, I've kind of made it my mission to educate people on this and to tell them about the importance of it. And when I'm talking about incapacity planning, I'm talking about the first 2 items. They're enduring powers of attorney and representation agreements. And the term incapacity or capacity is something it's pretty complex, and there's a threshold for it. So I'm not going to get into all the details about how the threshold is reached for a person to have lost capacity. But for the purpose of the presentation, just think about it as the point where you've essentially lost the mental wherewithal to take care of your financial and medical care decisions for yourself. So there's 2 incapacity planning documents, enduring power of attorney and rep agreement. They both do 2 really important things. The first thing is that they appoint people who are going to be in charge to make decisions. And the second is that they provide some instructions for how you want everything to be taken care of after you've lost capacity. The difference between the two documents is the power of attorney deals with all of your financial and business and real estate decisions, whereas the representation agreement deals with all of your health and medical care decisions. So I'm going to start with the power of attorney because it's usually where the most issues come up. Spouses will often assume that once their spouse loses capacity, then they will have an automatic right to access all of their personally owned bank accounts, deal with the real estate, deal with any business interests, but they don't. If you have any assets that aren't jointly owned, that are registered in that individual's name only, then those assets are basically frozen until the family members can get a court order allowing them to make decisions on that person's behalf. Getting that court order will usually take a couple months, and it's usually like at least $8,000. Whereas power of attorney, it's really quick to get in place and it's a lot cheaper. So that's powers of attorney that deals with all of your finances. Representation agreements are for the medical care decisions, and they're very, very important. But unlike powers of attorney, the legislation in BC for medical care decisions of an incapacitated adult, the legislation is actually pretty good here. In a pinch, doctors can consult with substitute decision makers, which is essentially if you have a spouse, then it's your spouse. If you have children, then it's your children. If you have parents, then parents, then siblings, then grandparents, and then I think it's grandchildren after that. They obviously all have to be adults, but there's a system in place for allowing people to step in if there's an urgent care decision that needs to be made about a surgery or life support or anything like that. And I used to, even like the last presentation, I think I remember saying that you don't always need a representation agreement. But over the last year, I've had some clients where I've been assisting with their parents' long-term care and getting them into a home and that sort of thing. And I've really realized the importance of representation agreements, because it's a really simple document that says, I'm in charge. I'm the person that can speak for this individual. So I find that, I mean, for urgent surgery decisions, there's a system in place for that. But if it is a long-term needs thing, I think a representation agreement, just like a power of attorney, it's a simple way of getting things done. Now, once the individual has passed away, then that's when the will comes into place. The representative appointed under the medical representation agreement and the attorney under the power of attorney both lose all of their authority under those two documents, and you can basically throw the power of attorney and rep agreement in the garbage, because that's when the will comes in. So I keep talking about estates and estate planning, but it's really difficult for me to explain how a will works without first explaining what an estate is. So it's basically all of your assets that are in your name alone, minus all of the debts and taxes that you owe on the date of your death. Canada doesn't technically have estate taxes yet, but there's sometimes a big tax bill on the death of an individual, because the CRA treats a person's death a moment before they pass away. They treat it as if they sold all of their assets and at fair market value. So there's usually a big capital gain bill owing. If you're transferring things to a spouse, you can roll that tax over, but a lot of the time there's a big tax bill that's owing. So it's sort of, the estate is basically everything that's left over after that is all dealt with. So wills have a similar primary purpose to incapacity planning documents. you're deciding who's going to be in charge, and you're giving them a list of instructions on how you want everything to be managed and distributed. As long as you're working within the confines of the law and you're adequately providing for your spouse and children, your will is basically your blank canvas. You can set it up however you want, and you can do a bunch of different things with it. It's a lot more malleable than the incapacity planning documents. It gives you an opportunity to have a say in things like the person who's going to be in charge to manage everything and distribute the assets over time. The guardians who are going to be responsible for taking care of any minor children who you leave behind. It's also a way of saying who gets your stuff. And it gives specific timelines and circumstances for how they're going to get your stuff. When I'm meeting with clients, I always use myself as an example, and I say, if I got a $250,000 inheritance when I was like 21, I would have immediately bought a 1970 Norton Commando motorcycle, and I don't know how to ride motorcycles. And I probably would have spent the rest at the Calgary Stampede or something stupid. So to avoid this, we often set up what's called a discretionary trust. So it's not a trust that's set up. You don't have to set up a bank account while you're alive. It's something that's triggered on your death that puts those assets into a trust that's managed by someone else up until your children reach a certain age. Some people, I mean, financial maturity, it depends child to child, obviously. Some people will say they're comfortable with their children getting an inheritance at 25 or 30 or 35. Usually no one goes beyond 35, because if they haven't figured it out beyond at that point, they're probably not going to figure it out. But those trusts are really flexible. So it doesn't say that, okay, you don't get any money until you're 35. It says if you are going to university, or I mean, it gives discretion to the trustees to make a decision that you think is appropriate. So if you're going to university, or if you're buying a house, or if you're starting a business, then the trustee has the discretion to dip into the trust fund before you've reached that age. And I mean, there's similar structures for if you have a disabled beneficiary. That's an area of law that I do a lot of work in, but you can set up a structure to ensure that that individual is able to receive monthly disability assistance on top of their inheritance and not get kicked off of some of the supports they already have. And discretionary trusts are also really helpful when we're dealing with a blended family situation. Because some people will want to ensure that, okay, my second spouse, I want to make sure that they're adequately provided for and they can continue to live in the home that we share while they're alive. But I also don't want everything going through their will. So you can set up a trust structure that sort of dictates that the surviving spouse gets a portion, and the children, once that surviving spouse passes away or gets into a new spousal relationship, perhaps, then the children, your children from a previous relationship, can receive those funds. So there's a lot of stuff we can do, but ultimately, I mean, with estate planning, I'd say about like 75% of the wills that I didn't draft that come across my desk will have a really similar structure. They'll say everything goes to spouse and then everything to children. And if no children, then to some other, maybe to their grandchildren or something like that. And that structure can work really well for simple estates where we don't have to navigate too many complexities. But there's a lot of things that you can do with the will that kind of goes beyond that and contemplates a bunch of different situations. So this is one of the reasons that I hate online wills, is because you want to contemplate a bunch of different situations. Ultimately, I think you want a will that is going to achieve a nice balance between structure that sets out what your wishes are, but also some flexibility. for the executors to be able to navigate different situations. I always tell clients that I can make you the most perfectly tailored will for your circumstances, that maximizes every single planning opportunity and saves you the maximum amount of taxes. All you have to do is tell me when you're going to die, everything you own when you're going to die, and the tax attributes of all of those assets. But if you're going to be difficult and hold out on me and not tell me that information, then I have to set up an estate plan that is flexible, that can adapt to the different situations. If you get divorced, or if you have more children, you have to create a malleable structure that can adapt to the different possible outcomes. Now, if you don't have a will, it's okay. You're not a bad person. If it makes you feel any better, I've been practicing in this area for my entire legal career, and I didn't have a will until this time last year. I probably should have done it sooner, but at the time, the only things that I had in my name were my 2018 Honda Civic and a mountain of student debt. But now I'm married, we have a condo, and we have a dog who's calmly sleeping under my desk. And I thought it was important for us at that point to get a will in place to make sure that we have a say in who gets to take care of our dog. So the chart that I have up right now, it sets out how everything is going to be distributed if you don't have a will. You might be looking at this and thinking, this is perfect. This is exactly what I wanted anyway. And that's okay, but it's always such a huge headache for dealing with estates without a will. Even if it ends up in the right hands, it's like an extra like 40 to 50 hours, or it's going to cost you more money. And it's good to get things organized so your loved ones aren't frustrated with you after you've passed away, I guess. So I started practicing in Alberta, and I always tell clients that it's way better to die in Alberta than it is to die in BC. And there's two reasons for that. One of them is probate fees. In Alberta, probate fees are capped at $525. That doesn't matter if you have a $200,000 estate or a $200 million estate. The only probate fees you're going to pay are $525. In BC, it's 1.4% on the gross value of the assets that pass through your estate. So ultimately, that's pretty much 14,000 on every million. And there's a couple ways of getting around probate fees, but it requires a little bit of additional planning. Wills variation is the other issue. Under wills variation rules, if you have a spouse or a child and a will, your spouse or your children can look at the will and say, I'm not getting enough money from the estate. And going back to this chart, if it doesn't line up with this, then they can make a claim that they should be receiving more. So this is a huge area of litigation in BC, and it creates a lot of tension within families. So when I'm advising clients on how to set up their estate, I'm also making sure that they understand the risks that they're taking on. If they say, I want to write a child out of the will, or I want to give my spouse 10% of my estate, you have to be mindful of the fact that there's a chance that they could challenge that, and that can kind of tie things up in court. So on top of traditional estate planning, as I've been talking about, and the wills and representation agreements that we were discussing, I wanted to let you in on a couple secrets. I told you before that probate fees apply on the gross value of the assets that pass through your estate, but not all of your assets are going to pass through your estate. There are some assets that transfer outside of the estate, and these assets won't be exposed to probate fees. So some people go really overboard with probate fee planning. And there's ways of doing it. There's simple ways of doing it. There's more complicated ways of doing that come with some risk. So you have to sort of balance the fact that, okay, it's 1.4% on the gross value of my assets, but it's also only 1.4%. So, I mean, you don't want the tail to be wagging the dog with some of this stuff, but I always encourage people to think about this to sort of minimize the amount that ends up going to the court and maximize the amount that's going to your family. So, one of these ways of not paying probate fees is through a beneficiary designation. So if you have a registered account like a RRSP or a RIF or a TFSA, or if you have life insurance, or some pensions, this applies to as well, you can name a designated beneficiary. So on your death, rather than having those assets pass through your estate and paying probate fees on it, they can just go directly to the person you've listed as the beneficiary. These are, I mean, it's pretty straightforward, and you can do this with the financial institution. A lot of the time you don't need to go to a lawyer to do it, but if you're setting up a beneficiary designation where you have multiple children and only one of them is listed as the designated beneficiary, then there are some legal issues that can come up where the other children can say, wait, that was supposed to go to the rest of the family, or that was supposed to go through the estate. So just be mindful of that when you're setting it up, and make sure that the bank has really, really good notes on file that say this is your intention. You actually want that to go to that. You want that account or that life insurance to go to that individual. Joint tenancy planning is something that I get asked about a lot. And with spouses, joint tenancy planning. So if we're dealing with a house and you have two spouses on as joint tenants, it's a really simple way where to have the house transfer from the two spouses together to one of them. They both share a 100% interest in the asset, and then once one of them passes away, it just automatically passes to the other. A lot of people ask me about listing their children on as joint tenants of a property, and this is something that can work, but it's also it also gets kind of complicated, because it usually works better if there's a situation where you're probably, like, if you have a terminal condition and your life expectancy isn't over a year. This is something that we sometimes might recommend depending on the circumstances. But once you make the gift, once you add that child on as a joint tenant, you can't really put the toothpaste back in the tube. You can't say, actually, you're not on title anymore. And there's also some tax implications and some complexity. So I know that there's a lot of people who ask me about this. If you have questions about it, please talk to me or another lawyer, because it does get kind of complicated. And the other way of sort of foregoing probate fees is having everything pass through what's called a joint partner trust or an alter ego trust. These are specific types of trusts that you can set up when you are 65 or older. It's good. I mean, I often recommend them if there's a situation where you're not giving everything to your children equally and there's adequate assets to justify it. Like, I wouldn't set up an alter ego trust if it's $200,000 worth of assets, because there's an annual tax filing that needs to be done for the trust, and it just kind of complicates everything. But if you're trying to avoid a wills variation claim, alter ego trusts and joint partner trusts are a good way of doing that, and also getting around probate fees. But it's all so circumstantial and situation dependent. It's such a lawyery thing to say, but it just depends. So the other things, that I wanted to bring up about wills, just taking it back to setting up your will, there's a couple different things that people are sometimes surprised by. So I wanted to just sort of unload my notebook a bit. Sometimes people will say, make a gift to spouse, children, and it's really simple. We can also kind of put some sprinkles on it. And if you are philanthropic and you want to make a gift to charity, you can designate a gift to charity in your will. Hub Cycling is an example of a charity, of an organization you can give gift to. You can also, in terms of appointing people, you can appoint multiple people to act together. So if you have 3 children, sometimes people will say, let's just appoint my 3 children together as executors or powers of attorney or representatives. When you're doing multiple appointments, you want to have an odd number. I'd much prefer that than appointing 2 children together, because siblings have a tendency to disagree about certain things. So odd numbers are usually better. Or if you are appointing 2, you can appoint a person to be a tiebreaker. And the other thing that I always challenge people to think about with their estate planning is, what happens if your spouse and your children and your grandchildren aren't alive at the time of your death? Where does everything go at that point? That's a question that often will lead to a lot of delays in estate planning, because most people haven't thought about that, and it takes them a while to kind of think through how they want to set it up. A lot of the time it'll be a charity or a family member. But it's an important thing. I'm always really focused on avoiding the 0.001% chance thing that might come up. So I always like to cover off every single possibility. Yeah, and then for if you have real property outside of BC, your BC power of attorney probably isn't going to work in that province. So you'll want to have a power of attorney there. Our wills are structured to try to capture all of your global assets. But if you have a condo in Barbados or a place in the States, I often encourage people to get a really simple will in that jurisdiction as well, that just deals with it, to avoid any potential issues. But make sure when you're doing that, that lawyer knows that you have a will in Canada, because you don't want that will to cancel the Canadian will. Other than that, that's estate planning. I'm sure you have some questions. So, and also the disclaimer, lawyer stuff, this isn't legal advice. Don't rely on it. Yeah, that's the presentation.
Fantastic. So I'm just going to join here as well to help facilitate the Q&A. So anyone, if you have any questions, please add them to the chat. I have a question to get us started off, because I'm really curious. I wanted to know, why should I go to a lawyer to get a will when I can maybe get one online?
Really good question. So those wills they work if you've got a really, really simple setup and we don't have to contemplate any potential issues. I practice in both estate planning before people pass away, setting up their estate plan, and estate administration, which is after people pass away, dealing with what happens and how to get everything distributed and going through the court to get the grant of probate. And I always find that those 2 or 3 or 4 page wills, there's always something weird that comes up where the executor needs to make investments on behalf of the estate, or the executor needs to make a payment to a minor, and it gets slowed down. And they're also really vulnerable to challenges, because they're not balancing that that structure and flexibility part that I was talking about before. So yeah, I mean, certain circumstances it can make sense, but it's usually a lot cheaper to get a good will in place than to get not as good of a will in place and then have your family have to deal with the fallout afterwards.
Thank you so much. Okay, great. We have a question here from John, who's just wants to know what are the pros and cons for tenancy in common versus joint when it comes to an estate, even when you have a will made up?
Mhm. So tenancy in common, the pro is that, I mean, the difference between joint tenancy and tenancy in common, for those who don't know, joint tenancy is that if I register this calculator in mine and my wife's name, then if I die, it goes to her directly. We both own 100% of it. If we own it 50-50 as tenants in common or some other 60-40, then when I die, we have to probate 50% of this calculator. It has to go through the estate. So it's a good way of sort of separating the asset. Sometimes we see it with blended family planning, where you don't necessarily want the surviving spouse to get the entire asset. You want that 50% to be guaranteed to go to your children. Cons are you paying probate fees on it, but or you might, you would in that case because you have to go through land titles. So there's benefits to it depending on the situation. But it's just like if it's tenancy in common with a spouse or tenancy in common with a child, there's a couple different situations that can come up there. So if John wants to reach out to me, my number and email are on this slide.
Okay, great. So far we don't have any other questions, so please add your questions to the chat. But as a charity, Hub Cycling, we're always curious about I think a lot of our donors are always looking at different ways to give. And I know that legacy giving is a really fantastic way of giving. Maybe some of you are wondering why Hub is hosting, a webinar about wills. Well, it's actually because wills can be one of the most generous ways to sort of give, because it's basically giving a gift that you don't get to see, but it's helping to shape the future that you want to have. So what are the other benefits of donating to a charity?
It makes you feel good about yourself.
Yeah.
If it's something you're passionate about. I mean, there's obviously the charitable tax credit, so you can reduce your overall estate tax bill if you are anticipating gains. That's a good way of offsetting those and minimizing the amount. You can kind of maximize the amount that goes to the places that you want. So maybe rather than giving everything to spouse and children, you could give a portion to a charity or an organization. And by doing so, that sort of reduces the amount you're paying in taxes and you're maximizing the amount that goes somewhere that you want it. So it gives you a say. And I always find that it's difficult with, I find that sometimes people, when I meet with them for the first time, they won't have considered charitable giving in their will. And I always find that it's on me as the advisor to inform them of that, because every time I do, they're always like, oh yeah, well, we give to Hub and we give to Canadian Cancer and all of that. So we should include that in the will. So if you're meeting with another estate planning lawyer who doesn't bring it up, make sure you remember that this is something that you can do, because it's a good way of just sort of supporting causes that you're passionate about.
Thank you so much. And we've got a few other questions here. We've got R, who's wondering, how much does a simple will cost?
This is another slimy lawyer answer, but it it depends. With estate planning, I mean, if like you can go to the online wills, it's a couple $100. I think Staples has a will kit that you can do that's under 100. You have to go to a notary to get it done. Like I said, those are the ones that are usually really problematic when the person passes away, but they can work. Going to a lawyer, it provides a little bit more certainty, and because we kind of have the training and we've seen all the ways that things can go wrong, we've set up our wills in a way that that contemplate all of the potential situations we've seen in the past. So we normally don't do a will without a representation agreement and an enduring power of attorney. But it really depends situation to situation and what we're dealing with. We don't do like estate planning packages. We just bill hourly, which I find is a lot more efficient because we do a lot of wills. So we've got a system down to get it done. But yeah, I feel like it just depends where you go. But I feel like our firm, given the lawyers that we have here and the situations we deal with and the complexity we've seen, we provide the best bang for your buck, in my estimation. I'm sure there's a lot of other firms that are going to say the same thing, but they're wrong.
Amazing. And the next question we have from Jerry and Nadia, I believe they were wanted to ask, how do you get your wife's name on the house title?
Yeah, so you can do if it's your principal residence, you can just do you can transfer. So she can transfer it for $1, love and affection, to get them in get your spouse named on title. You have to be mindful of things like citizenship if there's any issues there, but it's usually fairly straightforward. It's just a matter of going to a lawyer. Our firm does a lot of these transfers where you just kind of move it into both names. And like if it's your principal residence and you actually live there, then there's exemptions for the various real estate taxes that the province has introduced over the last couple of years when we're dealing with spouses.
Thank you so much. Our next question from CC, I really like the way they've written this, is a handwritten will that will say everything goes to Hub valid. If not, is there a way I can make a will without incurring any fees?
You're running a lot of risks there. Yeah, no fees is pretty difficult. Holograph wills in BC you can't really get them through the court system too well. So yeah, I mean, it might cost a little bit to set it up, but yeah, the whole writing it on a McDonald's napkin doesn't really work that well in our province. Sorry for Hub, by the way.
Yeah, that McDonald's napkin, I was really counting on it. Yeah, you can set it up with Max instead, and you can tell him everything goes to Hub. And awesome. Our next question is from Norbert, who's wondering, some of us have several citizenships with countries that have inheritance taxes. How do you minimize the impact?
It really, I mean, it's a question for a lawyer in that jurisdiction. I assume that, I mean, the US is a famous jurisdiction that has estate tax, inheritance tax, and the exemption threshold is probably, I mean, it might be changed. It really depends how this election goes. But there's certain, if we're talking about the US, there are certain types of trusts that can be set up to minimize inheritance tax, and gift tax, which is another thing there. But yeah, it depends circumstance to circumstance. The US is really is one of two countries that taxes on citizenship. Most other countries, except one, I think it's like Mauritius or something, and we don't have a lot of clients from there. We usually just deal with estate planning with US people, but yeah, so I mean, citizenship piece, it just depends what country we're talking about. So feel free to reach out, and happy to talk you through it. But largely speaking, you'd want to talk to an advisor in that jurisdiction.
And our next question comes from Tom, who's wondering, should your existing will be reviewed every 5 years?
Good question. Thank you for the setup, Tom. I when I'm setting up a will, I try to set it up in a way that it will be good for a number of years and you don't have to update it. So there's things that you can do, like flexible pieces, like saying, oh, rather than putting in the will, this person gets this necklace, this person gets this piece of art. You can have a side letter that deals with that, so you don't have to constantly keep updating. The reasons that you want to update a will are if you get divorced, if you have more children, if you lose any family members, or if the people you've appointed aren't the appropriate people anymore. Maybe it's a friend from a couple of years ago who you've lost touch with. So I've heard that you should update every 3 years, or you should review every 5 years or something. Just keep in mind who you have in place and update it when those people and those distribution structures are no longer appropriate. I think 3 years or 5 years is a good, it's a good way for people to remember. But the other thing is just think about the life events that come up, and if your will adequately reflects what you want at that time.
Thanks. Yeah, that's so helpful. And then Jerry and Nadia are wondering, if all assets are in both names, do you have to probate?
So this is another good question. And it's another great setup for me to talk about how probate works. So the reason that someone needs to get a grant of probate is because a registry or an institution requires you to provide one in order to access those assets. So those registries include land titles or ICBC institutions. I mean, your banks and credit unions. If you're transferring real estate, typically you will need a grant of probate to transfer real estate, unless we're doing a joint tenancy transmission between spouses. With ICBC, I think it's like, if your vehicle is worth over, I think it's 25,000, then they will require a grant of probate to transfer it into another name. And financial institutions, it depends institution to institution. So if you have, I think the threshold's usually somewhere around $10,000, they'll ask for a grant of probate. So if your spouses and all of your assets are jointly held, then typically there's ways of getting around probate. The problem that I often see come up is where we have a vehicle that's in one person's name. That's the thing that people often don't think about. So yeah, sometimes you can get around probate, but there's benefits to applying for probate because it gives you some certainty and it ensures that no one's going to come after you as the executor. But generally speaking, when we're dealing with spouses and everything's joint, then it's usually fairly beneficial to not have to go through the probate process, because it takes a bit of time, and as I said before, it costs a little bit of money.
Okay, great. And our next question is from Doug, who's wondering, can you please talk about appointing a professional as executor versus a family member?
Good question. So some people will appoint spouse first, then kids, then maybe a sibling, something like that. You can also appoint a trust company. So there's a number of really great trust companies that we do a lot of work with. It's the 5 major banks have their own trust companies. So RBC has Royal Trust, TD has Canada Trust. So they have these separate entities that manage estates, and they also can be appointed under powers of attorney as well. So they often do a really, really great job because they're professionals and they do it all the time. The problem sometimes is that they obviously charge a certain amount. So it depends on each trust company. Sometimes it's like 3% on the first 3 million and then 2.5% on the next, something like that. There's a structure in place, but so it will usually cost a little bit more, but sometimes if you don't want to burden your family members with the role of executor, or if you don't think they're going to get along and you don't know if they're going to be able to get it done, then a trust company is a great idea. I always encourage people to consider appointing a trust company as their final decision maker. So I like to have a couple backups included. And I always like to have a trust company in there because you know that a trust company isn't going to die. It's always going to be there. So it ensures some certainty.
And our next question is from John, who's wondering, what is the best tax-saving way to set up a property with land titles before someone passes to minimize tax/gains for children? Should children's names be added to land titles for a property before a parent passes?
So it's a good question, and it's one I get a lot. It's so much depends, because if it's a vacation property versus a principal residence, there's different considerations involved. I mean, if it's not a principal residence, it's challenging to get around the capital gain of that property. Usually the estate's going to have to pay it eventually, but there's certain things that you can do to transfer it efficiently. So it's one of those things that I'd love to have a bulletproof answer for you, but it depends on the circumstances, because if you're adding children to title, you have to be worried about, do they have creditors coming after their assets, or is there a family law claim that might, where if they're getting separated, that property might then be exposed as one of their assets. Like I said, you can't put the toothpaste back in the tube, so you can't take it back. And there's also residency issues. There's a whole bunch of stuff. And also, if it's a principal residence and they have their own principal residence, then it minimizes the amount that you can actually use as your principal residence exemption. So it's a whole bunch of factors to consider that I wish I could give you a good answer on this call, John, but again, feel free to give me a call, and I'm happy to talk through your specific situation with you.
All right, wonderful. That's all the questions that we have right now. Last chance to throw things into the chat there. Thank you so much, Max. This was incredibly educational, and yet you still make something that I think some people could find somewhat bleak, incredibly entertaining and informative. So we cannot thank you enough. Thank you everyone for joining today. Thank you so much, David, for joining us and having such a wonderful introduction. Do you have anything else to add?
Thank you, Max, and thanks everyone for tuning in. Keep riding your bikes. Stay safe.
Absolutely. Thank you all so much, and hope you have a fantastic day.
Bye for now.